Good evening, Judge Kathree-Setiloane.
Switch on the mic.
Please switch on the mic.
Oh, sorry. I'm so sorry.
Are you well?
Yes, thank you. Yes, in the circumstances.
I apologize to you that we took long before we could get to you.
Oh, understandably so. I understand the technical difficulty with having an online hearing, part online and part in-face hearing.
All right. Tell us about your experience as a researcher at the Constitutional Court and how enriching you believe that experience was. Just take your time. Tell us about your first experience before you became a judge, interacting with the first group of constitutional court justices, being part and parcel of that critical stage in the life of the court. Just tell us about what you gained and how.
Yes, Chief Justice. I had been interviewed by Judge Mokgoro while I was still teaching at the University of the Western Cape and working at the Community Law Center. And I flew into Joburg for the interview, and we had a very, very pleasant interview. And she asked that I work with her, to tell me that I have the job on the spot. And that evening, or the next day, I think, I was returning to Cape Town, and I got a call from Justice Mohammed to ask if I could come and be interviewed by him. And I then said, well, I've already been appointed by Justice Mokgoro. And he said, don't you want to reconsider and be interviewed by me? And I said, no. I'm very happy to be working with Judge Mokgoro. And so at the beginning of 1995 is when I came down to Johannesburg, moved to Johannesburg, and we began working in January. It was an amazing time at the court. I mean, it was the inception of the court. We had just occupied chambers in Brom Park, and we literally had to do everything, set up the library. The judges, most of them were away at that time. And Justice Chaskelson was there, basically doing all of the admin. And as the clerks came in, I think they were in those days, there were just 11 clerks. Each of the judges only had one clerk, save for Judge Chaskelson, who had two clerks, 2 or 3 clerks. It was such an amazing experience to be at the court at the inception, to be at the opening of the court, when President Mandela opened the court, to have had the opportunity to meet President Mandela on that day was just, for me, the best thing in the world, to meet Deputy President Thabo Mbeki as well. And to be a part of that very first judgment, that all of the all of the justices wrote in. And I think a lot of things that happen at the court now, and the processes that are followed by the clerks now, particularly the summary, the press summary, were things that started in our time. These were suggestions made by us at that point. We were involved in the editing process. We were involved in drafting research memorandums. We were actually treated like we were dignitaries, So if the judges were invited to conferences, we were invited to go along with them. I remember in that year, I was also given the opportunity to go across to Canada and speak at the Commonwealth Lawyers Conference. And that was because Justice Mokgoro couldn't attend. And it was during the time of hearings, and she gave me that opportunity. And subsequent to that, Judge Sachs also gave us an opportunity to join him on a trip to Wales and to Egypt, where he gave the Lord Borthegest address, and he took, I think, 5 or 6 clerks from the court with him, and we also presented papers at the conference at Wales University, and these papers were subsequently published. But it was an incredibly experience. I didn't intend to ever practice law. It was always my intention to go back to academic work, because I had barely, started being an academic when I took up the position at the Constitutional Court. But it wasn't a position that I was going to leave. In fact, I got the university to second me to the court. So but just watching counsel every day ply their trade. I mean, you got counsel from across the board, and I think it was that experience there that ingrained in me, the confidence to actually go to the bar and serve pupillage.
The practice, tell me if it is different from your time. The practice is, and has been for a while now, that a judge gets his or her clerk involved in the judgment writing process. You write the judgment, they do the research, but you afford them the opportunity to critique your own judgment and to even critique the judgment of other colleagues as part and parcel of the training process.
Yes.
Were you involved in that kind of exercises as well, or not yet?
Yes. There wasn't so much of critiquing as there is now. I find that the clerks are in a far better position now because they are really inside the mind of the judge. When I spent my 6 months acting at the Constitutional Court, unfortunately, the relationship soured towards the end with one of the clerks. But for most of the time, I had a fantastic relationship with both clerks and with the second clerk subsequently as well, to the difficulty that I had, which we all know about, and I don't want to repeat it here. But I remember before every hearing, sitting with the clerks, debating the issues, listening to their viewpoints. After the hearing, debating the issues with the clerks. I mean, for me, it was so important for the clerks to have an understanding of what I was thinking, and also to understand what their views are, because they were involved in drafting memos for me, in doing research for me on particular issues before hearing, after hearing, during the time that I was writing the judgment. I mean, I wrote the judgments myself. They don't write the judgments. But they assist you with memoranda on a particular aspect of the law, and it's all fantastic training for them. You actually see how the clerk's ability as a young lawyer starts to develop and where their interests lie. And so we were not as involved. I mean, I find that the clerks work much, much harder than we ever worked in that 1 year. And the processes are more intense, more streamlined. We didn't have, there wasn't the program. I mean, there's a distinct program that clerks have to follow. They have to attend meetings at a certain time with other clerks. There's a whole other timetable that the clerks have to be part of, outside of what happens with the judge and what happens in the judge's chambers. So I find that the clerks at the Constitutional Court work incredibly hard, and you have some incredibly bright young clerks at the court. And we see these young clerks, appearing before us after their time at the court and after serving pupillage or completing their attorney's exams. And it's really a proud moment to see young clerks. In the same way, it's a proud moment when I see my young clerks that have clerked with me at the High Court appearing before me and just performing so well.
Those who have read your judgment say you write so well. What would explain that?
Chief Justice, I think, well, thank you very much, firstly, for the compliment. My husband says I work myself to death. He says, you never come to bed before 2:00 in the morning. Sorry, I'm going to cry now, because sometimes I think that we get so consumed by our work that we neglect our family life. And fortunately, I have a husband who has been extremely understanding all through my time as an advocate at the bar and now as a member of the judiciary. And he gives me the time and gives me the space to actually be the best that I can be. And I'm forever grateful to him and for the rest of my family for that. So I do spend, and sometimes I find that maybe I'm just going overboard. I don't need to put this amount of time into my work, and I should, be more social. And but CJ, whenever you write a judgment, whenever you make an order, the consequences are so great, not just for the litigants in the matter, but for society at large. And it's a very, very, very lonely job being a judge. And particularly now, under the difficult circumstances in which we operate with COVID, it's been so incredibly lonely because you just don't have the support of your colleagues. You talk to them on WhatsApp, you talk to them on the phone now and again, but you miss that collegiality. You missed, just walking to your neighbor's chamber and bouncing an idea off them, or So it's writing judgments, and sometimes we take longer than we can, not because we are, not getting our work out timeously and not being efficient, but sometimes we take longer than we do because the issue is so difficult and the repercussions are so great and the consequences are so great that you sometimes feel, if I've written half this judgment, but I've just put it aside and I come back to it a week later, perhaps I'll have greater clarity. And that's why, the art of persuasion, the art of advocacy is so important. It is so incredibly important because a judge's life is so lonely. You need the help of counsel, to help you clarify the issues in your mind, to help you make that determination. And that's such an important part. And if counsel don't do that for you, you become very, very disappointed because you rely on them so completely for basically assisting you in arriving at the right decision in a matter. You don't always arrive at the right decision. It'll go on appeal and you may be overturned, but at least you gave the matter your fullest consideration. And I think that is the important thing. And you understood the factual matrix, and you understood the law, and you evaluated all of this, and you took both parties' arguments into account, and then drafted their judgment. So sometimes you get matters that are either right or wrong, and those are fairly simple matters. But you get the difficult, the complex matters where both sides could be quite right. So. Yes, CJ.
Yes.
I thank you very. Yes, thank you. I have no more to say.
How long were you on the bench when you were invited to act at the Supreme Court of Appeal?
I was on the bench for about 5 years, 6 years, or something. 5 years, I think. Yes, in 2016. Yes, early 2016.
Yeah. I take it you enjoyed your stay there, because I heard former president of the SCA, Lex Mpati, says she writes so damn well.
Yes, I did enjoy my stay. I really did enjoy my stay, and I was very disappointed that I wasn't called back. In fact, Judge Harty on a few occasions came to me and encouraged me to actually, apply to that court. And of course, I wasn't given the opportunity to go back. Yes.
How did you manage to navigate your space between a busy Gauteng High Court and the Competition Appeal Court, the Labor Appeal Court? How did you work your way around those challenges?
Yes, it's quite difficult because in the Competition Appeal Court we deal with matters in term that we're sitting in the High Court. So we sometimes sit, 2 or 3 times, 3 or 4 times in a term. Sometimes less, and with the Labor Appeal Court, fortunately, we are released. JP releases us from the High Court for 6 months to go across to the Labor Appeal Court. But the load of work in the Labor Appeal Court, and I find that court is not given the credit that it should be given. in the same way that the Competition Appeal Court is not given the credit that it should be given as appellate courts and as having basically the same standing as the Supreme Court of Appeal, So it's very difficult with the Competition Appeal Court because we very often asked to deal with the matter the last week of term, sometimes in the middle of the term if Judge Davis needs us. And fortunately, I've sort of approached Judge Sutherland and said, I'm in a competition matter, would you release me from something? And he's been open to that. The JP, I know, has been open to us also dealing with matters during term, and he will release us from High Court work. But it's always difficult getting the Competition Appeal Court judgment out, very quickly because they're very complex matters. And we also have, you almost need to get all your High Court matters out first before you can sit with your Competition Appeal Court judgment. And in the Labour Appeal Court, I think we get at least between 6 and 7 judgments a term, and they're fairly complex judgments and they require a lot of our time. Sometimes most of the time we're able to get, at least 4 or 5 of the judgments out in the term, and then we've got to reserve a few and deal with it once we're back at the High Court. So you then got to also juggle that with your High Court, High Court work. And it's, CJ, that I take my hat off to my colleagues in Johannesburg and in Pretoria. I mean, we are the busiest divisions in the country. And I have to especially compliment them in the way that they've operated during COVID. I mean, from day one, CJ, we were online, and I have to compliment our JP, From day one, we were basically online running our hearings. So, there were no setbacks in the way that court operated. Nothing was lacking. Everything that had to be done in the High Court got done. And I especially respect my colleagues that have been sitting in the criminal courts because, they basically went to court and they ran their criminal trials. And a number of them, I know of 10, 12 of them that had contracted COVID, but that still didn't stop them from going back and carrying on with their trials. So I do think that I'm very proud of the way the judges in Pretoria and Johannesburg have operated during this very, very difficult time. And it's not easy working online. It's very hard. It's lonelier. It's it's difficult. You have, like you've had technical hitches today. You have technical hitches all the time, particularly if you're dealing with trials. Applications run very smoothly. Urgent court. We do urgent court at least twice a term. It's been a lovely experience doing urgent court online, particularly over the weekend when you get a matter. It's really very, very nice to be able to actually deal with these matters from home and not have to leave your family on a Saturday afternoon, after lunch, to drive down and run the gauntlet of Johannesburg City to hear an urgent application, or Friday night at 11 o'clock at night or 9 o'clock at night or whatever. So I can really see that online hearings may be here to stay, especially in things like unopposed court, in urgent court. I think for the most part, during the day, the judge would probably be at the courthouse doing court work. But I think at night, where our nights can be very exceptionally busy in Johannesburg and Pretoria, I just think it's safer for judges to do this from home. There are certain challenges of transparency, etc. But I think that, if the press approach us, if members of the public approach us to be part of the hearing, to observe, we give them permission to do so. So it's not like we're locking out the public from hearings. There may be a problem with data, but we have, we have a system where lay litigants and other litigants that can't afford the expense of data, and we know that those expenses are very high. They can come to court, and their rooms set up at court for lay litigants and for other litigants, even if they're represented, to basically argue their cases online from their computer. So I think we've put in all of the court's taken all measures to ensure that justice is done, and the court basically continues operating effectively and efficiently during this time. And I particularly compliment my JP, and I see he's sitting here. JP, I don't think we could have done this in this time without your assistance. You really led us beautifully during this time.
Now that I'm satisfied, you're comfortable and relaxed, let me ask you the last question. You've been a law researcher at the Constitutional Court, High Court judge, practitioner, Competition Appeal Court judge, Labor Appeal Court judge. You've acted in the SCA and Constitutional Court. Now, just brag and tell us why you should not be left out as one of those to be appointed. Just, this is the only chance you have to brag.
Yes.
And once you're done, I'll be affording an opportunity to my colleagues to put questions to you.
Okay. Okay, I don't like bragging, but I'll take the opportunity. I mean, I think I've got experience across the board. I mean, I think by sitting in the Labour Appeal Court, I've got appellate experience for at least, I think, 7 to 8 years now. I've got appellate experience from the High Court, where I now sit as a presider in the High Court. Most recently, my JP has made me a presider in a very, very complex opposed motion. Normally, he presides in these very difficult matters, and I'm very privileged that he's given me that opportunity to do so. So I think, I mean, I thoroughly enjoy appellate work, and I'm very comfortable doing appellate work. I know people don't enjoy reading records, and I have a passion for reading records, and I see a case when I'm reading the record. I see it as if it's being argued. I've got experience across the field. I mean, I think now that the jurisdiction of the court is extended, I think experience in all areas of the law is important. We have a commercial court in Johannesburg, but where we do commercial court matters and precedence is given, priority is given to commercial court matters. But even before we had a commercial court in Johannesburg, Johannesburg is a commercial court, and a lot of commercial matters come to it. So I gained, experience in commercial matters, in public law matters. I did a lot of criminal law work while I was a judge. As a judge in the High Court, certainly in the first 7 to 8 years at the court. I've sat at the Competition Appeal Court. I've sat at the Labour Appeal Court. I've sat at the Supreme Court of Appeal, and I've dealt with some very, very good work. I was very fortunate to be given very good work while I was there, and I enjoyed that experience tremendously. And at the end of the day, I think I'm committed to the transformation project of our Constitution. And, I believe that it's important, I can make a contribution to transforming society through the Constitution and through the work done at the Constitutional Court. And I think I'm committed to social justice. Social justice is, the rule of law is an important aspect of social justice. I think I'm a woman. I think I'm a woman of color. I see myself as South African. I don't see myself as Indian. I always see myself as South African, but I understand that we categorize into Indian, African, etc. But I believe that I can make a contribution to the court, as a woman judge. And I can set an example as a woman judge, as the justice who I've worked with, Justice Mokgoro, and all the judges in the women judges in the appellate division and the Constitutional Court, they bring law closer to the young lawyer. They bring law closer to the young lawyer who doesn't even believe that he or she could become a lawyer or could work for a judge. And it demystifies this for young women all over the country in relation to, what they can achieve in the years to come, And certainly it makes it possible for young women to believe that there's a role for them to play in our judiciary and that they can climb the ladder in the judiciary and in the legal profession.
Thank you, Judge Kathree-Setiloane. Colleagues?
CJ. Nyambi,
Is
CJ.
Yes, Honorable Nyambi. Can I just have the names of colleagues who would want to follow, please?
Minister Lamula.
Yes, Minister.
Sylvia Lucas.
And Matolo Lepu.
No case.
This thing working. And the message of
Tepeche.
and Maton Seda.
I'm not sure whether you heard me. See, CJ Sylvia Lucas.
You are here, Honorable Lucas.
Marema.
Are we done?
Deputy President, ex-MPs, Chief Justice, thank you.
Makwanisha.
JP, you are not going to ask anything.
Makwanisha.
I'm on. Please note me.
Thank you. Okay. Honorable Nyambi.
Afternoon, Judge.
Good afternoon, Mr. Nyambi.
You have reflected on the views of former Deputy Chief Justice Mosenek on the challenges facing judiciary within the framework of transformative constitutionalism. What are these challenges and how best could they be overcome?
Yes, I mean, I think we've got this fantastic constitution and we have this beautiful Bill of Rights to test rise challenges against. And we've got, 20 some odd years of jurisprudence that's come out from the high courts and the constitutional court. But at the end of the day, the lived realities of the majority of South Africans haven't changed. So it's important for them, for economic justice and social justice to be brought to them. And I think the challenge of how, one transforms society through the Constitution. We are duty bound as judges to interpret the Constitution in a way that facilitates the transformative agenda. Social justice, economic justice are integral aspects of this. Whether we do it through workers' rights and giving workers, more than just, being laborers in the workforce, but giving them ownership of part of factories, for instance, or whether we do it through distributive justice. I think distributive justice is a very important aspect. Restorative justice and distributive justice are very important. And how do we ensure that ultimately, the poor, the underprivileged, the disadvantaged, those with no economic means, those that have always just been part of the working class, how do we transform, their status? How do we make it possible for them to move out of the situation that they're in, so that in time they will benefit, they will be the beneficiaries of transformative justice or the transformative agenda of the Constitution? Justice Moseneke postulates a number of things that could be done. But I think it's a challenge for the court. And I think what has happened over the last few years is the court hasn't had that many socio-economic rights cases coming to it. It's the political disputes that the court is majorly dealing with right now, and I just think that in time, there needs to be, the court has said, and the Constitution's vision is that you've got to have a substantive understanding of the Constitution, standing understanding of the concept of equality in the Constitution. So how do we create opportunity through the law? It's not, the challenge is the court deals with what it gets. It works within the confines of what the dispute is that's before it. But at the end of the day, this largest social transformative project of the Constitution is something that has to be undertaken jointly by the different arms of government. So I think the court plays an important role in interpreting the Constitution, in keeping the powers of government in check, in ensuring also the other arms of government in check, ensuring that the other arms of government are carrying out their functions, ensuring that the other arms of government are carrying out their obligations and duties under the Constitution. But it's a wider project because, we have a right to shelter, perhaps a right to shelter. No, I don't even know if it is in fact a right to shelter. I think that every person should have a roof over their head. And I think, there's the right to water. There's the right to healthcare. There are all of these that create the opportunity or create, and I deal with the values of freedom. I deal with the values of Ubuntu. All of these things are so necessary for our citizens to have economic agency, basically. And I think without economic agency, and it's really very difficult to improve one's status, without proper education felicities. I think courts need to do more. And I think, there's a lot done in the field of education rights. There's a lot done in the field of health rights. But it's a joint project at the end of the day. So, the executive have to be involved, Parliament has to be involved, the judiciary is involved. So ultimately, this whole transformative project has to be a joint project for us to actually succeed in bringing to bear and in achieving the broad transformative objectives of the Constitution here. So there are a number of challenges going forward, and it can't be left to the courts alone. It has to be a broader effort, I think.
Thank you. My last question. I'm happy that you are the one who raised what happened the last time you were here.
Yes.
Especially that issue of the clerk, but I don't want us to go back to that issue. We are forward looking. Given an opportunity now, because we normally say experience is the best teacher. With the hindsight, reflecting what you said then in responding to the JSC, what might be things that you might consider as your weakness or lesson you learn out of your responses then, so that we can assist us to have a clear picture?
Yes, I think it's important that, and I have to put, I'm sure you're aware of it, but the subsequent complaint has been dismissed by the Judicial Conduct Committee on the basis that the allegations were not substantiated, and I was basically accused of coming before this commission and lying to the commission by the clerk. These were all completely unsubstantiated allegations, and the decision makes that very clear that these were unsubstantiated allegations made against the judge, in stating that I was dishonest before this body, and you know, the decision basically states that those are serious allegations to make against a judge, particularly when none of those allegations are substantiated. And it's made quite clear in that decision that when I responded to the questions of the Chief Justice, I was basically putting my version of the facts to him, and that I wasn't at all being dishonest. And that was clear from both the transcript of the proceedings and the, you know, I responded to the complaint on affidavit. The complaint was not made on affidavit against me, but I responded fully on affidavit. My response was also supported by the affidavit of the second clerk, Mr. Refiwe, and she basically distanced herself from all of the allegations that was made by the young clerk at the time in relation to the way to the fact that I was being dishonest at this. You know, I think I took my relationship with the clerks for granted. I'm a very compassionate person, and I take seriously what I do. And, you know, perhaps I ought to have checked the way I responded to my clerks, and just be careful the next time, so I don't create expectations. But I would never ever want to go through that experience again, Mr. Nyambi. It was a terrible experience for me. I could have, you know, on the Saturday when I received the memorandum from the judicial conduct, from the JSC, I could have actually withdrawn from the process. But I needed to I needed to attend the hearing. I knew it wasn't going to be a difficult hearing, but I garnered all the courage and all the strength. And after discussing it with my family and my husband, I decided that I had to come before the commission and put my version of the events. You know, the sad part is that I think we sometimes take it for granted, and I think we were trained in that way, where if we did something wrong as young clerks, or if our work wasn't up to scratch, up to standard, we were immediately told by our superior, okay? And we learned from that. And perhaps, you know, we need to rethink going forward, because the youth are completely different from, you know, they have experienced life differently from what we experienced. For us, it was difficult getting those jobs. And when we got the jobs, we were so grateful. And when we got those jobs, we were prepared to work after hours. We were prepared to work weekends. I remember when I worked at the Constitutional Court, I would never leave the Constitutional Court before 11 o'clock at night. All my colleagues, we all stayed at the Constitutional Court to 11, 12 o'clock at night until whatever we had to do was done. In the weekends, we were at the Constitutional Court from Friday to Sunday. And that was the work ethic. And perhaps the work ethic is different with the youth these days. But I think I've learned that you know, that we have a different work ethic. We have a different work ethic from the youth, and maybe we have to be a little bit more patient with them. And you know, I have learned from that experience. I was hurt. I was more hurt than anything else. You know, coming before this commission was difficult, but I think the hurt still remains with me, because, and Refiwe has come to me and she's hugged me and she's apologized and she said, "Judge, I am so sorry. I am so sorry." You know, I have clerks. I had about 6 or 7 clerks in the High Court now, and Desmond Rapanyane is my current clerk. And, you know, when we have differences, I raise it with him and we deal with it on the spot. And that's done and over. And the very next day, we continue from where we left off, you know. So I think it's so important in the way that we manage our relationship with the clerks to I think to deal with things up front and and don't let it simmer, I think, I also have a very authoritative manner, and sometimes that's perceived incorrectly. And, I think when we deal with younger people, we deal with the juniors that work under us, we need to show a little bit more compassion, I think, But I think it's so important for them not to take us for granted, because we all work so incredibly hard. And we employ them. I employ students from university, straight out of university. My clerk came from the University of the North, having put himself through studies. And I want him to learn, so I'm going to be firm with him. If I think that he's shirking his responsibilities, I will be firm with him. But the point is that I need to raise it with him immediately and get it done and over with, so he knows and he has learnt from that experience and he won't repeat it going forward. I think that's the important thing. And I think to the extent that we, from time to time, we take counsel to task, okay? I think when we take up positions as judges, we don't do it for popularity. As I said earlier, it's an incredibly hard job. Every order that we make, whether it's the smallest unopposed motion or the most complex opposed motion, every order has tremendous consequences. And from time to time, and because we run such a busy court, in a single week, we can have 15 opposed motions, very complex opposed motions. You can have 3 to 4 appeals, which are very complex appeals. And if counsel unprepared, it really disappoints us. And we, at the end of the day, have to ensure that counsel represent their clients fully, competently, and efficiently, and that counsel assist us in that task, of ultimately having to make that decision and write a judgment. If counsel comes to court unprepared, if counsel comes to court having not read their papers, I will on the spot reprimand counsel for doing so. So counsel, some counsel have said they have not had a very pleasant experience. But what does that mean? What does it mean you haven't had a pleasant experience? Does that mean that you lost the matter? Does that mean that I asked difficult questions? Because I will ask questions. Because the only way I can get to the point of being comfortable with taking a decision for the one side or the other is if I have clarity in my mind as to the law, as to the facts, and particularly the facts. And that's why it's so important in appeals and applications for counsel to know their papers, to read their papers, to have all the material allegations in their papers. So I link the whole clerk thing in with counsel as well, because at the end of the day, with counsel, you're also dealing with egos, boundaries are sometimes crossed. But I think at the end of the day, you have to ensure as a judge that justice is going to be done, that the counsel is representing his or her client adequately, that counsel follows the etiquette of the court, that counsel follows the appropriate decorum. And I have to say, in 99% of the time, it is such a pleasure. It is such a pleasure to have counsel before you. And you are so grateful to counsel for being so well prepared and actually making the case easier for you. And you thank them at the end of the day, to say, thank you very much for this contribution that you've made, with your argument, with your heads of argument. So it's just, I think I've learned that, and I think, from the early days being a judge, I think before Judge Mojibelo, Judge Malambo became the head of the Johannesburg High Court, we were dealing with up to 380 unopposed matters on a single day, in the Johannesburg High Court. So you'd get these papers on a Friday afternoon at 4 o'clock, and you've got to work through them over the weekend and deal with them on Monday. And by Monday night, you're getting another 15 or 20 opposed motions to deal with. There was no time to breathe. There was no support whatsoever for judges. You know, we were just presented with these things and we had to get on with the job. And if counsel came to court unprepared, if counsel papers were not in order, if counsel made submissions that were not consistent with what's in his papers, we would have to take them to task. We would have to
CJ.
interrogate the issues.
CJ,
Is that Honorable Malema?
yes.
Oh, yes, Mr. Malema.
Yes, Honorable Malema.
I think that in as much as we want to give candidates an opportunity to express themselves, but there should be a point where they stop so that we can also ask questions. If they speak alone, then there's no point in interviewing them.
All right. Thank you, Honorable Malema. Honorable Nyambi, are you covered? Have you been answered?
Thanks, Judge. I'm covered. Thanks, CJ.
Thank you very much. Minister?
CJ, can I make a quick follow-up on the same? And if I'm covered, you can even remove me from the list.
Okay.
On the
All right.
same
Go
point,
ahead.
I want to check. This clerk we're talking about with Honorable Nyambi, is it the same clerk you spoke about earlier when you said you enjoyed working with the clerks at the Constitutional Court
Yes.
until there was a problem at the end?
Yes, I thoroughly enjoyed working with the clerk. I had a very good relationship with the clerk. She was, you know, I enjoyed working with both the clerks. Yes.
Thank you, CJ.
Must I remove you now, Honorable Malema?
No.
Honorable Minister, over to you.
Thank you, CJ. And I'm not sure whether it's now evening or afternoon.
4:45, I think,
Yeah.
early evening.
Is it your view that judges should only speak through their judgments?
Yes, I think it's safe to speak to your judgments only, Minister Lamola. I think it's very safe to speak to your judgments. Only, I think we can get ourselves into unnecessary trouble if we try to defend our judgments outside of the judgment itself. Yes.
Do you think that policy-centric considerations should be borne in mind by judges when making their orders or judgments?
Yes, I think it's important. And I think, I mean, in terms of whole separation of powers, you know, we all have functionally different, we're all functionally different, the executive, the legislature, and the judiciary. You know, I think we have to be vigilant to considerations, policy considerations, particularly polycentric policy considerations, that may fall outside the realm of the judicial role and what we can intervene in. But I do believe that if policy is inconsistent with the Constitution, the constitutional provisions in the Bill of Rights, then we are mandated by the Constitution to actually intervene in that dispute and to make a determination. But I think, you know, there has to be a balance between the vigilance of intervening in these matters and the functionalities and of the executive and the legislature.
Maybe last follow-up is on the first question. Why do you think it's important that judges only speak through their judgments?
So we don't get ourselves into unnecessary trouble. I think traditionally it's been the role of the bar to defend a judge when his or her judgment or when his or her conduct is criticized by the public. And I see that is still the role, you know, of the profession. I know now that the Office of the Chief Justice has a spokesperson, and that spokesperson, from time to time, when judges are attacked, when their judgments are attacked, or they attacked in their personal capacities or their capacities as members of the judiciary, that the Office of the Chief Justice, through its spokesperson or through the Chief Justice, will step in, to set the record straight. But I'm aware of very few cases where judges actually, defend their judgments publicly and outside of their judgments itself. I mean, at the end of the day, you have an appellate process. Judges are allowed to be wrong. If you are wrong, then the appellate court will overturn you. And I think we work within the confines and the safety of knowing that if we are wrong, and we will always be wrong, but when we're wrong, we know that there is an appellate court that will actually set that, overturn that. And if we're right, of course, they'll uphold your judgment.
Thank you, CJ.
Thank you, Minister. Honorable Lucas.
Thank you very much, CJ. Good afternoon.
Good afternoon,
Judge
Good afternoon.
Setiloane. I was listening to you, and I was also reading through your resume. And I really want to start to commend you on the fact that you are still making a lot of time to engage on women's issues and to also elaborate on the development of women. And also the acknowledgement that you are standing on the shoulders of strong women, like Judge Yvonne Mokgoro. It is something that I've noticed. And before I come to the few questions that I had, I thought I should really commend you there on.
Thank you.
And
Thank you,
also that you acknowledge that we are still transforming. We are not an ideal society, so there are still many issues that need our own attention. I was just in Parliament busy on the last 15 months with the review of the Women's Charter. It was quite an elaborate program of Parliament, and that is the reason why I've noticed that you are being involved and engaged with many of the issues that is addressed in the 12 articles of the Women's Charter. But according to your view, Article 2 of the Charter speak about the law and the administration of justice with regards to issues of women, particularly the focus on the economy, currently violence against women, but also the issue that we have observed in some of the provinces is cultural and customary issues. What is your view with regards to what the court, particularly the Constitutional Court, and also the legal fraternity can contribute to make sure that we do assist women to overcome the difficulties that they experience within that specific realm?
I think that rural women specifically are worst off in society, and a lot more needs to be done in relation to their plight. They are they are subjected to customary law, and customary law is not a bad thing. I support customary law as an independent area of the law, and I believe that it should have the same standing as civil law and the common law. But at the end of the day, like the common law, customary law must also be consistent with the Constitution. I do think that I think it's a larger project than just what the Constitutional Court can do. I mean, of course, it can give a substantive understanding and interpretation to the Equality Clause, to the discrimination clauses, to ensure that opportunities are created for women, whether it be land rights or ownership or areas concerning, their own safety, their security and safety. I think all of that's important. Well, that applies to women across the field. But I think there's a need for so much more education around women's rights as well. And there's a need, particularly in the rural, to go out to the rural areas and educate women about their rights, because you can have a women's charter, you can have this beautiful constitution, and unless that constitution and that charter has a real impact on women, whether they be urban women or rural women, it's going to make absolutely no difference to their lives, and they'll never be empowered by it. So I think it's important in terms of land tenure, ownership of land within the customary systems, for women to be involved in the leadership structures, the customary leadership structures, so that decisions are made that impact positively on women. Women's rights in the economy, women's rights in the process of allocation of land, the rights of young girls. Yes, I mean, I just think that, and I mean, the safety of the women's safety and security of women, that is such a huge issue. And again, the courts have pronounced on rape, on incest, and meted out harsh sentences. But I think at the end of the day, it's an area that's so large and so complex, and so much more effort needs to be put into it, and so many more resources, government resources, have to be channeled in that direction. So, for instance, it doesn't help just to raise these issues and make them mainstream during, Women's Week, for instance, or Women's Day, but it's something that has to be happening every single day. We have to have women in our minds and at the forefront of transformative constitutionalism at all times. And, we need to use the rights in the Bill of Rights and interpret them in a way that facilitates a substantive application, understanding of the rights in the Bill of Rights, so we can basically ensure that the plights of women, whether they are women in the rural areas or women in the urban areas, whether they're rich or poor, but at the end of the day, that their safety and security is enhanced, and that their positions in society, and they play important roles in the family, they play important roles in the clan. They play very important roles to maintain cohesion. And unless we support women and we protect women through this and ensure that their rights are achieved through the constitutional interpretation of rights that apply to them, we're going to always subject women to the violence that they now experience. And we're now in 2021. Women shouldn't be feeling unsafe anywhere in the world, but unfortunately, women are still feeling unsafe. Women are still not achieving what they should achieve in the workplace, etc., because they are held down.
Thank you. I just want to solicit your comment on what I'm going to say now. In most of the instances, in actual fact, the women felt that what is really deepening the crisis for them is the lack of compassion from the side of law enforcement officers, as well as our courts and our judiciary in general. Just a short comment on that.
Yes. That's an excellent question. That's an excellent question. We can never bring access of justice to women if women do not feel like their needs are being taken care of by the courts. I mean, I think the mindset of courts have to change towards women. I think judges, I think magistrates have to be put through education programs. And I know over the years, the Department of Justice has done a lot more in running courses to sensitize judicial officers, to sensitize magistrates, particularly in the regional courts and the other lower courts, in the way that they deal with cases relating to gender-based violence, rape, etc. So, you often hear that a woman was in a trial and, her case, she didn't feel like she was given a proper hearing by a male judge because there was no understanding of her plight. She wasn't given adequate time to put her story forward. But I think over time that has changed, and the courts have become more sensitive, I think, and more aware of the need to approach matters pertaining to women in a different way. I'm not saying that there mustn't be equality of the way a judge deals with, of course you deal with all your matters equally and give them equal importance. But I do think that when a woman is subjected to violence, rape, you have to bring a particular understanding to that trial when you're listening to evidence. Thank you.
Thank you very much, CJ. Thank you.
Thank you, Honorable Lucas. Commissioner Matolo Debu.
Thank you, CJ, and good evening, Judge.
Good evening.
Mine is just a comment. I know that you are one of the women judges who are very supportive to young women lawyers, and you've been running workshops for the women in law, it's anytime we call you. But what I want to know is that how do you think we can expand the program? I mean, the excitement of young women was very visible to you. So how do you think we can expand that and also include our male judges?
Yes. The education program that was that I presented lectures to, by the Women in Law project. By the way, it was very encouraging. There were male participants as well. There were some male attorneys that participated as well. They've asked that this program be repeated again this year, and judges get involved in it again. I think that last year there were just 2 judges involved, myself and my sister Weena. And Victor, Judge Victor has done tremendous, in fact, she brought us to the organization and she got us involved in this. I mean, it's really a program that is there to empower article clerks, to empower young practitioners, attorneys, advocates. So there was attendance from across the board. There were lots of academics there as well. And it was, in fact, the time allocated wasn't long enough because the discussions went on to early evening. And, the women, the request came from the women themselves that they want a repeat of this. So I do think that, even outside of COVID, I mean, I think it was necessary because it was COVID and you were not having face-to-face presentations where you could, go to conferences and make these presentations. And, but I do think that even when we manage to get out of this very difficult time an unprecedented time that we're in, that programs of this nature continue. I mean, I think they should also, incorporate sensitivity training, and I know we do that. That happens for in the High Court. Judges undergo that kind of training, and I'm sure it can, that can be replicated for the legal profession as well. But it's important that not only the small firms are involved in this, and single practitioners are involved. It's important that the big law firms, the big corporates, also, play a role in this, because we see with each year that the candidates that are employing are mostly women, These law firms are employing are mostly women, and the women are now the top students that are emerging from the universities. So I think it's very, very important that programs of this nature be replicated across the profession. It will empower women, but it'll also empower men. It will help in their development as lawyers, and also assist in their skill set. And I think at the end of the day, it is true to, we have to not only live out the Constitution when we sit in court as judges, but we have to ensure that the Constitution is applied in our lived realities as well. And I think this will make us all better individuals at the end of the day, and better practitioners, and basically elevate the standards of the profession.
Thank you, CJ.
Thank you, Commissioner Matolo Zepu. Commissioner Nokesi?
Thank you, CJ. Good evening, Justice.
Good evening, sir.
Yeah, the only thing that troubles me is the record of your interview in April 2019 about your relationship with the clerks. I hear you say that matter has been solved. But the fact of the matter, what comes up to me is that it reflects that you generally don't have respect for juniors to you. That's what comes up from this record. That's one. The second point from your record is that, in fact, admittedly, you say you are a short-tempered person.
No, I didn't say I was short-tempered, sir.
But this is what I find from the answers in the debate between yourself and Mr. Nyambi around this question. My point is, have you sorted out those things, or what is your response? That's what troubles me in the whole matter. Yeah.
Yes, Mr. JSC, I have tremendous respect for my clerks, and my JP will tell you, and he has constantly told me, Faiza, you have managed to have the best clerks and the most efficient clerks. You managed to attract the best clerks at the High Court. I have no difficulty. I'm a judge now I'm going into my 11th year. I've had no difficulty with any of the clerks. And like I say, I still maintain a relationship with all my clerks. My current clerk has been with me for 4 years. I have had no difficulties with him. We have a beautiful relationship, and he will vouch for that. And all of this is all of this is on paper. Clerks, my mentees have all put in testimonials on my conduct. I am very passionate about what I do. I am very emphatic when I deal with matters, and I will robustly intervene if I am unhappy with your conduct. Judges are human beings. We are not robots. We are not automatons. We have emotions as well. And, I see it sitting with my colleagues. I mean, we all have moments, difficult moments in court, and may from time to time show a little impatience, but that doesn't mean that we are not giving providing the parties with a fair hearing. Like I said, I think I've learned over time, and it's now, in my 11th year, to approach issues with clerks differently. I have tremendous respect for my clerks. I am completely involved in the empowerment of my clerks. I'm involved in their careers going forward. I'm there with them, assisting them with all of that. So I have tremendous respect for young people, and people that know me know. And I think my JP can vouch for that. I have tremendous respect for young people. It gives me, it's such a pleasurable task. And I said this earlier, I enjoyed working with the two clerks at the Constitutional Court in the same way that I enjoy working with my clerks at the High Court.
Now,
thank you.
Justice, look, I'm happy that you have answered this, because this is exactly the impression I have, and I don't want to prejudice you. Lastly, this is my second question. What is your view as a judge, I mean, particularly of the Supreme Court, about the standard that the judges themselves, in relation to those that they interact with, that they should exhibit or they should reflect in terms of their own fairness. I'm taking into account from your statement that you are a fair person, you are firm, you are all, but the point is, how should you relate with those that interact with you in a manner that does not necessarily reflect your own attitude, or it's not reflective of an attitude from yourself?
Yes. I mean, I think particularly in appellate matters, you haven't had an opportunity to listen to the evidence or to argument firsthand, and you are then confined to a record of the proceedings. When you prepare for an appellate matter, you go through the record thoroughly. You got to have, you got to know the factual matrix fully. And I think when you go to court, you ask questions. You have to ask questions, and you sometimes ask difficult questions. Perhaps you take a view on a particular matter. You ask questions, and you ask the questions not to trick counsel, not to make the hearing difficult for them. You ask questions because you need assistance and you need clarification. Because at the end of the day, you have to make a decision. Particularly, you're sitting with 5 judges, or you're sitting with 11 judges, or you're sitting with 3 judges. Your colleagues may have a different view from you. You may have a different view from them. But the important thing is to interrogate the issues, so counsel can persuade you on which way to go. So it's so important. You will, in all appeals, I think in all appeals, you take a view when you go into court. But I've often walked out of court with a completely different view. And much to the surprise of counsel, my judgment goes completely differently from the approach I took in court. And that particular hearing was a complete success. And that counsel, who I may have not been, I may have not been with, in the sense that I didn't take the same approach, had managed through proper advocacy and the art of persuasion to convince me that my, the line of reasoning was incorrect and I had to change. And I would go back and I would then write a judgment, with a different point of view. But you've asked both parties hard questions, basically.
Thank you, Sir. I'm happy with your answers.
Thank you, Commissioner Nogesi. Commissioner Mpofu?
Thank you very much, CJ. Yeah.
Hello, Mr. Mpofu.
How are you?
Good, thank you.
Justice. Thank you very much. Well, maybe I can just take advantage of the fact that I've probably known you longer than most of the people around the table, since the days when you were a pupil.
Yes.
And I wouldn't say I've followed the career, but at least I've seen the various stages. And I think I can assure Commissioner Nogesi that the issues that you have raised, at least in my experience, that have been my experience. Many qualities have been mentioned here about what is needed from a judge. And one that has not been mentioned, which I can attest to you have a lot of, is judicial temperament. And as you say, that doesn't mean you don't ask the difficult questions. In fact, I know that you do. Sometimes when you go to court, you wish there are always 2 or 3 questions you wish a judge is not going to ask. And you're one of those judges who will probably ask all 3. So I think and also in the competition appeal court where I've encountered you, I found that the approach was quite fair. But I'd like to ask you something completely different. And again, I'm taking advantage of the fact that I know you too well. I wouldn't ask this of someone else because it's a bit personal. We live in a country that is racially complex, with gender discrimination, at very sharp levels. Your surname is Kathree-Setiloane, so you have crossed some of the cultural boundaries that define us as South Africans. And in my view, that's something that may either enrich your experience as a judge in terms of interacting with different people from different cultural backgrounds, probably has enriched you personally, and maybe also some members of your extended family on both sides. What have you learned from that personal experience of being a person who has, in your family arrangements, crossed those boundaries? How would that benefit the bench, if you know what I mean? Or how has that benefited you or enriched your own life experiences inside and outside of the bench?
Yes, Mr. Mpofu, I think when as a young activist, I was asked by an elder uncle of mine, if you are really committed to the end of apartheid and to transformation in this country, then will you marry a black man? And I said, yes. I used to call him daddy. He was an uncle, but I called him daddy. And I said, yes, unhesitatingly. And I have a wonderful family. My husband's family are wonderful people. I had a wonderful father-in-law and mother-in-law that passed on. They're a rich family. We have a rich family life. We support each other. We see each other often. They have helped me live out the life that I've always wanted to live out in this country. I didn't want to be separated out. And I take objection to the fact that I'm called Indian, because I see myself as African. I see myself as African. I see myself as South African. And in fact, I had a robbery at my house, and the policeman arrived, and he was taking down my statement. And he said, Kathree-Setiloane, I am an adult African woman. And I said, my God, you know what would happen to me in court if you state that I'm an African woman? And he said, but I'm looking at you and you're an African woman, and I get called Makoti all the time by my hairdresser and everybody else. So I didn't make the wrong choice. It's enriched my life. It's enriched my association with my colleagues. It's enriched me as a lawyer, as a judge. And I bring those experiences to bear in the way I decide matters. Our matters are, there's certain value judgments we bring to the whole aspect of judgment writing. And if anything, being married to my husband, being part of his family, and to see my family interact with him and love him as their son, is just very enriching for me.
Thank you, CJ.
Thank you, Advocate Mpofu. Commissioner Tsepe.
Thank you, CJ. Good afternoon.
Good afternoon.
Evening,
Good
Judge.
afternoon, Mr.
Very lovely to see you.
Thank you.
Chief Justice, the issues I needed to raise regarding gender issues have been dealt with by Comrade Lucas and Commissioner Matolo-Lepu, and I won't raise them. The one issue I wanted to discuss with you relates to the Chief Justice. I think you need to call Commissioner Mpofu to order.
Sorry.
Well, I thought you started it all by saying comrade.
Sorry, comrade.
This comrades, man.
Thank you, Chief Justice.
Please proceed, Commissioner Tsepe.
Judge Kathree-Setiloane, I wanted to take you to back to where the Chief Justice gave you an opportunity to have bragging time, and the issue you raised about your commitment to transformative nature of our Constitution. I just wanted to know what has been your experience in specialist courts or when dealing with commercial matters to the observance of by judges of the constitutional obligation in Section 39(2) of interpreting legislation and developing the common law and customary law to promote the spirit, purport, and objects of the Bill of Rights. And if there are cases that you have penned that shows your or reflects your observance of this obligation, if you could just take us to those. Thank you.
Yes, I think that I have in a case developed the common law, but not through the prism of, well, I mean, I suppose through the prism of 39(2), but not because the common law was not consistent with the Constitution, but rather that it was in the interests of justice. I think in terms of 173 of the Constitution, to basically develop the common law. And it was, sorry, let me just quickly, I could quickly just look at my application. It was a matter between Absa Bank and I think it was SPAR, just SPAR. And it was in relation to ensuring that there's no economic loss when a bank basically returns a payment, you know, that the bank needs to do more. When a bank gets an instruction to return a payment, and the bank has to do far more than just basically, without contacting the payee or the beneficiary, basically return payment, particularly where there are risky circumstances. You know. So the bank basically, you know, banks are basically now duty bound to ensure that there's no economic loss when reversing payments. So they need to take steps beyond what they currently do and not make inquiries with the party that would have been the beneficiary of the payment or the payee, basically.
Thank you, CJ.
Thank you, Commissioner Tsepe. Commissioner Madonsela?
Thank you, Chief Justice. Although I've been partly covered, it means that my question will be just a short one, and I'm hoping that the judge is going to answer it quickly without wasting time. Good afternoon.
Good afternoon, Mr. Madonsela.
Yes, Judge Kathree-Setiloane, I've looked at your CV and I've looked at your work as a judge. It's very impressive, and you have delivered very good judgments, although in one of them I was on the losing side.
Yes. But you presented beautiful argument to you, and I think I told you that.
Yes, but it didn't start well.
Yes, it didn't start well.
And that's where I want to zoom into.
Yeah, yeah.
And let me preface my question with an observation that I make. I've appeared in the high courts, in the SCA and in the Constitutional Court. My experience is that the higher you go, the mellower the judges are. And I've always wondered why judges of the High Court are so, if I can use the word, cantankerous. Are very impatient with people. And I get that distinct impression about you.
Yes.
And I got it actually when I was there in your court. That you seem, you know, even in your interview here, and much against the testimony the testimonial received from Mr. Mpofu, You are very firm with people. You are impatient with them. Tell counsel, take counsel to task. If counsel is not prepared, get deep disappointed. You are worried about the youth of these days who are not grateful about the opportunities given to them. You tend to demand too much from people around you, as if they should, as if they must live up to your standards. And that might not be necessarily a bad thing, and I'm not quite sure what your standards are, but from what I read, you're a person of high standards. Why is it so that you can't just exercise some patience with those who are much weaker than probably you are? And I tell you why I ask this question. As an advocate, as counsel, or you get much from me when you make me comfortable around you. And I don't see that you are such a person. And that's why I want to go back to this judicial temperament issue, that it seems to me that whilst we have all the attributes of a good judge, you seem to just not to be lacking on this aspect of being patient with counsel, and thus being able to bring much from counsel than it is present in the situation. Am I wrong in that? And can you just allay my fears insofar as that aspect of your judicial attribute is concerned?
Yes, Mr. Madansela, I do take a very robust approach, and I do expect high standards. And the irony of it is I do it in order to uphold the integrity of the court, and I do it to uphold the standards of the profession. We were expected to perform for a very high standard when we were advocates at the bar. Like I said, in Johannesburg, that must have been in my very early years, my first or second year of being a judge. And I think over time, I've also mellowed. I've also mellowed. And perhaps I was more impatient at that point, but I've mellowed. Even though I may have been impatient, I allowed evidence to be led. I allowed for the argument, for full argument, and I considered both, full argument before I wrote the judgment. Being a judge is not easy, Mr. Madansela, and I'm sure you've now acted as a judge.
But I'm very mellow when I'm a judge.
You're very?
Mellow.
Oh, well, you're a mellow person. You see, you're a mellow person. And I think you're probably a mellow person, and I'm not a mellow person, but I try my best to be mellow. And perhaps I had a menopausal moment, you never know. I mean, we're all going through those difficulties. As women, we have to be honest, We have absolutely no support, Now we have a little bit more support. In the past, we had no support. In the days where you appeared before me, we had absolutely no support. When I said we had 300 matters a day to deal with, we had that. So I think over time, I think we all learn. And I think I have learned as a judge. And particularly by sitting in the appellate courts, I've learned. I think we're a little bit more cantankerous. And I think you use the right word. I mean, I sit with my male colleagues, and they are even more cantankerous than I am, for God's sake, When I appeared before my male colleagues, when I was an advocate at the bar, God, they were incredibly irascible. I mean, completely cantankerous. I mean, you were terrified to appear before them. I have counsel saying to me, Judge, that we've had good experiences before you. I get counsel coming back and reporting to me. I get my colleagues coming back and reporting to me. Everybody knows I'm a firm judge. And as a result of being a firm judge, but they know I give them a fair hearing and I give them a full hearing. And as a result of doing that, counsel that have previously not performed well in my court come back to my court, and we are great friends. So I generally have a good relationship with counsel. And I said, it's not a popularity contest. It's a difficult job. It's such an incredibly difficult job. And we are human beings at the end of the day. And
thanks.
Yes.
Honorable Malema.
Thank you very much, CJ. Good evening, Judge.
Good evening, sir.
What is your understanding of judicial overreach? And do you have an examples you can give us on judicial overreach?
Yes, my understanding of judicial overreach is when the courts intervene in matters that are in the terrain of the executive. I mean, I don't believe that the Constitutional Court may have been criticized from time to time for intervening in issues pertaining to Parliament. The EFF matter, EFF UDM versus the Speaker of Parliament is one of the matters. There was dissension in the court itself on I think the Chief Justice said that this is a classic case of overreach. My view was quite different. I believed that there were certain obligations that Parliament had to carry out under the Constitution, which it hadn't done so, and on that basis, the court intervened, and the court then made an order, obliging Parliament to do what it had to do. In this case, it was to put in place rules, impeachment rules. So I believe that, and I dealt with this somewhat when I answered Minister Lamola's question. Where there's a fundamental right that is violated or infringed, courts are duty-bound to intervene. We are duty-bound to intervene. Where there's a constitutional right, even if it's outside of the Bill of Rights, that deals with functions and powers of other branches of government, and any conduct that is inconsistent with that, or policy that is inconsistent with that and the Bill of Rights, we are required to intervene. We are mandated in those cases to intervene.
Can the Constitutional Court sitting on the bench there take away a fundamental right of an individual, like in the Bill of Rights, where the court says to a person, your right to remain silent is taken away? Can the court do that?
No, it can't.
And if the Constitutional Court does that, what recourse do you have?
Well, I think the Constitutional Court is the last court. I don't believe the Constitutional Court will do that. It will never take away a right. And it hasn't done that so far, from my understanding of the jurisprudence that's emerged from that court.
This is just a comment, Chief Justice, because I'm going to raise this point when we meet.
I was hoping you were not going to go there, Honorable Malema.
There's a comment because I'm going to raise it and I don't want to be accused of being unfair to you. And you'll comment if you want to. I'm going to argue that you're condescending and you treat juniors as kids, and you don't take into consideration that the courts themselves, just the building and the benches, are designed to intimidate. And when you come in a manner you are coming, and the manner you are saying you are coming to people, you are actually worsening their intimidation, and as a result, they are unable to express themselves, and they end up misrepresenting some of the counsels, their own clients, because of what you call firmness, which at times comes as if it's rudeness, and you call people youth, adults who have gone to school, who have graduated to come and work with you. And I think you call them youth because you are here. I get a suspicion that you at times get tempted to refer to them as kids, and you treat them like kids. You're puppeting them. And if that is the approach, you can be guaranteed the youth I lead, you're going to fight with them many times. This is a new youth. We are not the old youth that has accepted condescending attitudes.
I'm sorry, Mr. Malema, when I speak of the youth, I'm not talking about children. Youth can be up to 35 years old. You know that you can be part of the youth league if you up to 35 years old. I am not condescending to my juniors. I really am not condescending. That hasn't been my attitude. if anything, I encourage youth. I encourage the young people that work with me, the young adults that work with me. That has been my experience always, you know. I really am not rude. I certainly am not rude. Firmness cannot be mistaken for rudeness, Mr. Malema. All judges are firm. We are required to do a job, and we have to do it efficiently. And at times may come across as being robust, but we have a duty to the litigants to ensure that they are properly represented. And I said, in 99% of the cases, the litigants are properly represented and counsel's performance is immaculate. There may be a small percentage. I have had counsel who were unprepared before me, who have come back fully prepared. And we have a great relationship. I am not condescending to young people. In fact, I'm very popular amongst young people. And if you know me and you know my relationship with counsel at the bar, and you know my relationship with the young clerks at the court, you will know that I am not condescending to young people. I show compassion. I help build them. I empower them to the extent that I can. I have a number of mentees that were clerks of the Constitutional Court, that were clerks of other judges, that still have a relationship with me and will call me. Mentees that run organizations today, mentees that went on to work at the Supreme Court of Appeal, mentees that are currently doing pupillage at the bar and call me from time to time for advice. So I am not condescending to young people. I have extremely good relationship to young people. There may be a small percentage of the bar that, you know, that felt that I responded differently to them, but there was no malice in that. I'm sorry, you know, I will not accept that I'm condescending to young people. And I will not accept by referring to young people as the youth, that I'm referring to them as kids. The youth are in fact young adults.
Yes. Thank you, Judge. Deputy President Betze.
Thank you, Chief Justice. Good afternoon or good evening, my colleague, Judge Kathree-Setiloane.
Good evening.
Mindful of the fact that I'm only allowed limited questions to ask, I will cut to the chase. And my apologies in advance if my questions somehow ruin your good mood, but I'm duty bound to ask them. I'll start off with the penultimate paragraph of the letter of nomination by Judge Murphy, it is. And I'll go to the relevant portion where she says, when he says, I beg your pardon, when she differs, she being a reference to you, open quote, she does so gracefully and collegially, close quote. And my first question to you, do you truly subscribe to this statement, or perhaps are you just paying lip service to this principle of collegiality?
Justice Petse, my colleagues will tell you that I've been very collegial in the High Court. I'm not, when I differ, I state my view. And, that's been my experience. I haven't been uncollegial. I haven't been impolite. I have colleagues who have been impolite to me when they took a different view. But at the end of the day, we discuss our views. I certainly haven't been impolite to my colleagues, and I don't know of any colleague of mine that has indicated that I've been impolite to them, or that I've been not collegial.
Thank you. I'll ask you about an incident that occurred sorry. Thank you. I'll ask you about an incident that occurred at the SCA, of which I'm aware. You were part of the panel of 5 judges who had a particular appeal on the 26th of February, 2016. And one of your number was, as is customary in the SCA, assigned to write a judgment. He wrote his judgment, produced a draft, circulated it amongst the members of the bench in that case, as is the convention. It was 11-page judgment. You read the judgment up to page 6. And you approached that colleague and said to that colleague, this judgment is not up to scratch. I will not waste my time reading it further. You will have to write this judgment all over again.
No, sorry, Mr. Petsy, I think that's not correct. I don't think that's correct. It was my colleague from the High Court, Judge Morasoka. I was reading. I didn't even know what we're not actually told how you're supposed to approach the judge when you write, in relation to how you bring your comments to them. Because Justice Soka was a friend of mine, I approached him in chambers. I read the judgment and I felt there were certain things missing. And ultimately, one of the other judges had written large aspects of that judgment, had completed a lot of the things that I would have pointed out. As a colleague, I thought, Justice Mora and I are from the same court. There are things that I thought had to be put in. And I thought as a colleague, it was collegial for me to go into. I never said to him that your judgment wasn't up to scratch. I never said that. I never said that at all. I had made insertions in the judgment and I asked him to consider that. But I read it till page 6 and I had all of these things and I thought, let me go to him and ask him if he'd like to reconsider, inserting certain things in the judgment. And he took offense to it. And I left it at that point. I didn't take it further. I actually left it at that point. I didn't mean to offend Judge Soka in any way. Judge Soka was my colleague from the Joburg High Court. There were times where he gave me his judgment to look at. And he said to me, I'm giving you the liberty to basically do what you want to do with my judgment. That's the kind of relationship I had with him in the early years. And I apologized to him for it. I didn't understand the process. I thought that maybe, because I was handwriting and making changes in the judgment. And I thought if I go and discuss it with him as a colleague, but he felt offended. And I said, I'm sorry. And I left it at that. And at the end of the day, one of the other judges, one of the other very senior judges, had basically made exactly the same changes in the judgment that I was suggesting to Judge Moore. And I'm sorry that he took offense to it. It was not meant to be that way.
Thank you. And indeed, your comments or your inscription go as far as page 6. This is where you left it.
No, I read the whole judgment. I did read the whole judgment, but I had made changes and I wanted to discuss those changes to that point. You know, he didn't accept them. I read the whole judgment, and then within a day of me, or within the same afternoon, or the very next day, there was a whole new judgment that was produced by one of the senior judges that basically added to the content of Judge Morwa's judgment, and it took care of my concerns, and I left it at that. So I didn't have to comment further on it.
Chief Justice, this is a follow-up question. I know that you have disputed what I've put to you, but at a level of principle, do you think if indeed you said what is attributable to you, would it have been collegial of you to tell a colleague your judgment is not up to scratch?
No, sir,
You have to rewrite it.
No, sir, I didn't tell my colleague his judgment.
No, I accept that.
Yes, I didn't say that.
Yes.
But it would have been wrong for me to say your judgment is not up to scratch.
Yes.
But I did not say the
No.
judgment is not up to scratch.
I'm sorry for the interruption.
No problem.
That's the point I was putting to you at the level of principle. And this ties up with your firmness that you have been bold to tell us about. There's nothing, in my view, wrong about being firm. But when you are firm, you must be sensitive, and your firmness must be tempered with politeness. Do you accept that proposition?
Yes, sir. I accept that your firmness must be tempered with politeness, and I haven't been impolite. I don't take a firm approach with my colleagues. I certainly am polite with my colleagues. I'm polite to counsel. I'm generally polite to counsel. There may be one or two instances where counsel felt that I was being impolite. That is a view. That is a view. There are always other views. There were also other counsel in court. I am sorry if I was impolite. I didn't mean to be impolite. But as women, sometimes we are, when we are assertive, when women are assertive, they are seen to be impolite. They are seen to be too dominant. They are not viewed well. But when males do the same thing, it's completely accepted. It is not seen as impoliteness. It is not seen as rudeness.
I will not enter that controversy. Lastly, I just want to put this to you, that when you express your views, you have to do so bearing in mind, or you have to be sensitive about how you do so. Not so?
Yes, exactly. Yes, exactly.
Thank you,
I
Chief
agree.
Justice. I have no further questions.
Thank you, Deputy President. Honorable Magwanisha.
Thank you very much, Chief Justice. I'm covered. Thank you.
So, JP.
Thank you, Chief Justice. Judge Setiloane, I just want to check one thing with yourself. You are applying to go to the Constitutional Court, and you've sat as a judge of the High Court, the Labour Appeal Court, the Competition Appeal Court, as well as the SCA in acting capacities. I've mentioned the Labour Appeal Court, isn't it? Are you able to tell us which of your judgments have been upheld by the Constitutional Court and which have been relied on or cited with approval? by the Constitutional Court?
Yes, I think the McBride judgment has.
Only that one?
Yes, I think that one has been cited by the, I'm trying to think if there was anything else. I think that has been cited by the Constitutional Court, yes.
I see.
And I think the SCA has cited some of my other judgments.
Yes. And I just want to deal with this issue that the Deputy President of the SCA, that's my second and last question, CJ, that some people experience you, in a different manner. But I just want to recount my meeting with you when I took over as JP. You remember I came to your chambers, you were shocked what I was doing there. And I had just come to set my mind straight about what I had heard, right? And we talked generally, and you did say, JP, I'm assertive, I'm firm, and some people experience that as rudeness or whatever, but this is where I come from. And I walked out of your chamber understanding how you operate. Do you confirm that meeting?
Yes, I do.
Yes. And you've been a judge of the High Court under me since 2012 to date. Are you able to tell the Commission if I've ever had to intervene between you and another judge because of a disagreement?
Never. Never, sir.
Or involving a secretary?
Never.
Thank you, CJ.
Thank you, JP. Judge Kathree-Setiloane, have you experienced or heard of the top 6 at the Supreme Court of Appeal and how they apparently treat colleagues or those junior to them?
Yes, I think that's something that's, well, from time to time it's been in the press about, there have been complaints.
How does it compare, based even on the experience of candidates who were interviewed here, to what you are being accused of?
Oh, so I do think that, I think that the top 6, they expect high standards and they will intervene and they will undo your entire judgment if they're unhappy with it.
Have you? Yes.
Yes.
What I want to know is what you have done. Is it any higher than what the top 6 have been accused of doing to junior people and colleagues?
No, sir. I've not done anything like what they have been accused of doing.
Yes. Now, you were asked about judges talking through or speaking through their judgments. Honorable Nyambi referred you to reflections by former Chief Justice Langa and former Deputy Chief Justice Moseneke on transformative constitutionalism. Was that in judgments or not in judgments?
I think that was the reference to transformative constitution by Judge Langa, I think was, that was an article I had written, that was published in Acta Juridica. It wasn't in a judgment, yes.
He was addressing a meeting and an article was subsequently written out of that address, is it not so?
Yes. It was a conference that I was asked to present. It was the conference...
No, referring to the one of Justice Langa.
Yes, the Justice Langa one was, I think he had stated the whole issue of, he built on the whole issue of transformative justice in an article or a speech he had given that was subsequently published.
That's right. And the same applies to former Deputy Chief Justice Moseneke, is that not so?
Yes, he had written a book on economic justice, yes.
But that was a speech. I'm talking about his speech that later emerged as reflections on transformative constitutionalism.
Yes.
Now, the notion that judges must speak only through their judgment, does it mean that judges should no longer address conferences, or what does it actually mean? Must no longer deliver lectures? What does it mean?
No. I think we allowed, in terms of the code of conduct, to deliver lectures, to address conferences on topics, but the point I was making to Justice Lamola is judges don't don't defend their judgments.
Yes.
In the media.
Yes.
Yes.
That's how I understood you. I thought he was asking a different question, but
Okay.
thank you very much. You're excused.
Thank you very much.
Thank you, Judge.
Thank you, Chief Justice.